fact that I booted up, suited and booted on a Saturday morning, but I felt it was appropriate if I was going to be here on the panel this morning, particularly talking about some of the historical aspects of the Second Amendment. And I'm going to throw in another amendment that you may or may not be aware of that we passed in Wisconsin, Article 1, Section 25 of the Wisconsin Constitution. Just to kind of give you a little backdrop of what the issue involves and how it has evolved. What you may or may not have heard this morning if you were listening to your radio, there were a number of shootings last night. I'm just giving you some background to kind of tee up the issue. Concerns about how those shootings played out. There was a tactical situation that was over in my neighborhood yesterday that fortunately did not result in gunfire that took place. We were fortunate that ended peacefully, and it will be dealt with, I'm sure, in the courts over the course of the next week. But there are a number of issues that involve violence, that involve the black community, that involve the city as a whole, that involve the county, that involve the state and the country. And there are very strong feelings about the possession of the right to possess firearms by all citizens in this country. So I thought it would be helpful to kind of give some of the little bit backdrop of how this amendment has evolved, because everyone assumes that it started with the Second Amendment, and as is the case with most of our laws are based on historical passage of law, or not passage, but historical approaches of the law that come from England. And some of them have to do with very serious situations that involve the transition of the throne in England. And the transition of the throne in England that I'm talking about is that back in 1689, when, as a result of Catholic leadership and King James, I think James II, if I've got it right, there were some difficulties with how he was dealing with Protestants and how he was using militias basically to suppress Protestants in England, and he was run out of the country. He was exiled. And a Bill of Rights was passed in 1689, known as the English Bill of Rights. It is complicated, it's long, I'm not going to go into all of it, but there are a couple of provisions that I think are relevant to our discussion here, because the United States Supreme Court in Heller actually referred to this as the genesis, the beginnings of the Second Amendment to the United States Constitution. The two rights that they talked about was that the raising or keeping a standing army within the kingdom in time of peace, unless it be with consent of Parliament, is against the law. And that was, of course, a reaction to the fact that the king was using the militias to suppress Protestants. The second was that the subjects which are Protestants may have arms for their defense suitable to their conditions and is allowed by law. It was not an absolute provision when it was presented back in 1689. It was a provision that was designed to protect Protestants only. It was a provision that was designed to protect against government, to protect against the king, to protect against Catholics, and to promote the interest of Protestants. That is the history of the genesis of the English Bill of Rights that led to the Second Amendment of the United States Constitution. And just to make it clear, so that there's no confusion that the United States Supreme Court recognized this, I'll just read from Antonin Scalia's opinion in the Heller case that came out in 2008. Between the Restoration and Glorious Revolution, the Stuart kings, Charles II and James II, succeeded in using select militias loyal to them to suppress political dissidents, in part by disarming their opponents. Under the auspices of the 1671 Game Act, for example, the Catholic James II had ordered general disarmaments of regions home to his Protestant enemies. These experiences caused Englishmen to be extremely wary of concentrated military forces run by the state and to be jealous of their arms. They accordingly obtained an assurance from William and Mary in the Declaration of Right, which was codified as the English Bill of Rights, that Protestants would never be disarmed. And then the provision that I just read to you. That right has long been understood to be the predecessor to our Second Amendment. To be sure, it was an individual right not available to the whole population, given that it was restricted to Protestants, and like all written English laws, it was held only against the Crown, not Parliament. All right. It was that bill that led to the creation or the adoption of the Second Amendment. And what you have to understand about the Second Amendment is that it was not originally part of the Constitution. By its very nature, amendment. It was an amendment to the Constitution. It was felt that it was important that it would be added to the Constitution. That's kind of the genesis of how this came into being. So the question becomes, well, what does it mean? And then let me just back up and just tell you what the Article 1, Section 25 reads, because you've already heard Mr. Anderson read to you the Second Amendment in its whole. And let me just repeat it, because we need to understand what we're talking about here. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, Wisconsin has passed a similar amendment. It's worded differently, and I just want to highlight some of these. The people have the right to keep and bear arms for security, defense, hunting, recreation, or any other lawful purpose. All right, those are the two amendments that I want to just kind of highlight and talk about. All right. So, how do we interpret? What does that Second Amendment mean? It's the question that was asked of this very panel. Is it absolute? Does it apply across the board to everybody? Does it provide everyone totally the right to bear arms? Now, there are a number of policy reasons that people might debate as to why it would be a good idea, a bad idea. I'm going to leave that to the policy makers to argue their positions of whether they think it's good or bad. I just want to talk about how it's been interpreted by the courts. The case that really kind of looked at this clause, the Second Amendment, looked at all three individual clauses, the militia clause, security of the free state clause, the right of the people to keep and bear arms, in saying that they shall not be infringed. The court in United States versus Miller interpreted this in the context of a possession of a short-barreled shotgun case. And the court looked at that amendment and said that in the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly, it is not within judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. The Constitution, as originally adopted, granted to Congress power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, and so forth, with obvious purpose to assure the continuation and render possible the effectiveness of such forces. The Declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view. In other words, the court back in 1939 in a unanimous ruling said that the clauses were linked, that you had to relate the purpose of the amendment to the actual amendment's protection itself. Now I can tell you, and I want to talk a little bit about judicial philosophy here, because judges take different approaches in how they interpret laws. Some are textualists, some are originalists, some believe in, as Warren Burger coined the term, it was not Earl Warren as many people think, it was Warren Burger who talked about the living Constitution and how it should be interpreted. Well, I happen to view myself as a textualist. It is very difficult for a judge to try to figure out what somebody meant to do when they pass a law. It is much easier to figure out what they did when they passed the law. So if you look at the words of the law, it's an easy interpretation if you can figure out what the words mean. When I look at the Second Amendment from a textual approach, and I'll talk about this when I talk about the Heller case, I'm not sure that the Miller court got it right in 1939. You have a purpose, a preface, and you have a right. Does the right have to be linked to the purpose? That's the question. That is the question. Now the court said it had to be linked. That was the interpretation. That became the law. And there is a large body of case law from the United States Supreme Court and Supreme Courts throughout the country that say that once a court interprets a constitutional provision, that becomes the constitutional approach. And it's up to the people to change the Constitution if you want to change it. So whether you agree with or disagree with the approach the court took in Miller, it's clear what they did. They took the Constitution, they said these clauses are linked, that it has to be linked to the purpose of a militia, and therefore we have the right to regulate how guns can be utilized, how they can be held, how they can be possessed, and this particular provision is a valid provision restricting the right to have a sawed-off shotgun. Now that's what the Miller court said. Now like I said, you can agree or disagree with it, but that's what the court did. All right. There's another body of law that constitutes stare decisis, that we stand by things already decided. And so the courts, once you have that interpretation, typically are bound to follow that interpretation. That's what courts are supposed to do. Now we all know, everybody knows, and everybody has times when they agree or disagree with courts do this. The courts don't always do that. Courts don't always follow the prior precedent that has existed in previous decisions. Sometimes the courts are upfront when they overturn something. They look at something and they say, this was wrongfully decided, we are overturning. Sometimes the courts will look at the passage of law and interpreting a constitutional provision and say, well, due to the passage of time and the change in circumstances, we are rethinking our position and we are coming down with a new conclusion. Sometimes courts will say, we didn't say what we said. And that's essentially what happened in the Heller case in interpreting the Miller case. And in an opinion written by Justice Scalia, who takes a very textual approach in looking at the language of the amendment, it's kind of hard to ignore the language that says, the right of the people to keep and bear arms shall not be infringed. That's what the language says. Now, if that's the right, unless it's linked to the preface, a textual approach is looking at that and says, well, that's the right. And that's essentially what the court said. Heller basically backed off of Miller. It didn't overturn it. I want to be careful about how I say that, because overturning it is a big step for a Supreme Court. It's saying that we got it wrong before. And what they said in Heller was that we didn't say what we said in Miller. I challenge you to read both cases. You'll see what I'm talking about. The Miller case clearly linked the clauses. The Heller case unlinks it. All right. But the Heller case made some other interesting observations. I just want to point out a couple of them, if I can pull it up here just quickly. Because the Heller case understood some of the policy considerations that existed with creating an absolute approach to the right to bear arms. I mean, there are a lot of interesting questions that creates. If the right is absolute, does it mean the felons have the right to have guns? Does it mean that we can control how they are carried and transported by various either state laws or municipal laws? Does it mean that they can, that the states can pass carry and concealed weapon laws, which has been a big issue in our state? And the Supreme Court made it a point to note, and I'm reading now from Justice Scalia's opinion, like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explain that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. Nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. What Heller said is that you cannot create a blanket prohibition of the people to have weapons in their homes. When you are at home, you cannot, by legislation, say that the person in that home cannot have a weapon. You can't tell them that the weapon has to be unloaded, because what's the point if it's an unloaded weapon? You can't protect yourself. All right? That's what Heller says. The Wisconsin Supreme Court in Fisher, in interpreting the slightly different but similar amendment, Article 1, Section 25, and also in Hamden and Cole, looked at these issues as they impacted the Wisconsin Constitution, and came to a similar approach in Hamden, saying you cannot preclude the right of a store owner to protect themselves within the confines of their store. They were recognized in Cole and in Fisher that the interests of the public were not as secure when you talk about transporting it in a vehicle. And the purpose may be important as well, because if you look at the facial constitutionality of carry concealed weapon laws, facially they're constitutional. It's okay. Once you make the determination that the right is not absolute, as the United States Supreme Court has done, it then becomes a question of, okay, you recognize that regulation is appropriate. You said it's okay to keep felons from firearms. Who makes the determination of which regulations are appropriate? And how does that interpretation get decided when it gets to the courts? And from my perspective, coming from the judiciary, I think decisions about regulatory matters have to be left to the regulators. You elect elected officials, whether they be state legislators, whether they be aldermen, whether they be county supervisors, to pass laws that govern how things are supposed to take place in your community. Some of the laws we have on the books, for example, I think one of the municipal ordinances provides for how people can transport weapons. I'm really getting hooked here. So, how people can transport weapons in the trunk of their car, whether they can be loaded or unloaded. The Fisher case dealt specifically with the purpose of a gun owner to just have guns in their vehicle, not for purposes of security or protection or defense or hunting, but just because they wanted to. And the court in Fisher said, well, that's not a legitimate purpose. You got to relate it. But the passage of the laws, in my view, belong to the regulators. The court then has to interpret when there's a challenge to the constitutionality as applied to that individual. The courts determine whether that's reasonable. And of course, because that's a case-by-case decision and it doesn't apply across the board, that gets tricky. Now, there's a lot more to this issue, but I'm going to leave that to the policymakers to discuss whether or not they're good ideas or bad ideas in terms of how that regulation gets created and interpreted. But to answer the question that we were asked to deal with, is it absolute? The United States Supreme Court and Wisconsin Supreme Court have recognized the answer is no.
Thank you.